Lawyers' resistance to mediation as a means to resolve design and construction disputes, at least in my view, is typically based on a number of factors. And certainly one is bad experiences with bad mediators and bad mediations. And I have to tell you that certainly mediation is no panacea. I have been involved in my fair share of extremely frustrating mediations, which are handled in the wrong way, the table is set the wrong way, and it actually tends to exacerbate the dispute. And so mediation is no panacea, and I wouldn't argue otherwise. But I do think that sometimes these bad experiences with bad mediators and bad mediations can tend to get stuck in lawyers' heads in ways that are not constructive. And confirmation bias, I believe, with mediation is real. The tendency of people to favor and focus on information that confirms their existing belief. And I've seen just far too many lawyers who have had some bad experiences in mediation, and then they're just going to write mediation off forever. And, this is certainly one of the reasons, in my opinion, having litigated design and construction disputes for more than 20 years, why lawyers tend to resist mediation as a means to go for that early cost-efficient dispute resolution in design and construction disputes. There's other reasons. I think that, a belief in many lawyers that an adversarial information exchange, a discovery battle, depositions, exchange of documents, motion practice, battle in the courtroom is the best way to convince other parties that their positions are untenable. And that has certainly not been my experience. Increasingly, I'm trying to figure out a way to come in the back door. I'm looking for the short way around the block. Increasingly, before I'm ever going to file a lawsuit, I am going to have collected all my clients' emails, and I will certainly know 10 times more than the other parties. And I have the ability to put right in their face, let me show you some stuff that is going to make you decide to settle at some point. And, why do we need to fight for 2 or 3 years before you're going to discover this stuff on your own? When I can show you another way of getting this information. So I personally do not believe that this adversarial information exchange, this super inefficient means of exchanging information through court procedures, is a good way of convincing the other party that their position is untenable. I certainly am increasingly focusing on other ways of doing it. And then I think that there is this optimistic overconfidence in the merits of our client's position. I mean, look, I'm an advocate. I've been litigating for a long time. I, tend to, like many advocates, get blinded by certain facts that help me, and I tend to not see facts, that don't tend to, prop up my client's position. And I think that this optimistic overconfidence in the merits of our client's position, which oftentimes is driven by sort of intentional selective attention to facts, right? I'm going to focus on what I think helps my client. I think that it blinds us as attorneys regarding the other party's position, and specifically that it might be reasonable. And so the question is there a process where we can, use to overcome some of this optimistic overconfidence in our own position, so that we have a little bit less of the selective attention to facts. And I think that lawyers also tend to object to mediation because their confidence in, what's going to happen when a judge, sees their motions or sees, some of the arguments that they have to make in court or arbitration. And it's certainly true that in the rare case, there's a dispositive ruling on a motion or some really important deposition that is going to really change the case. But there's no reason why those depositions can't happen outside the context of litigation. Certainly there are ways of conducting mediation, and this is one of the tenets of guided choice dispute resolution, that information can be exchanged and obtained in a wide variety of efficient ways. We certainly do not, I believe, need to be in court litigation, being supervised by a judge and going through that grinder of years of expensive and time-consuming exchange of information, just to test the confidence of the legal positions that the parties have set out. And, I think that one of the most insidious reasons why design and construction lawyers resist mediation is the false view that agreeing to mediate is a sign of negotiation weakness. And, you want to talk about how people's personalities can get in the way of early cost-efficient dispute resolution. It's almost like Back to the Future, where Marty McFly would go crazy every time somebody would call him chicken. And I believe it's certainly certainly a false view that agreeing to mediate is a sign of weakness. And I think that increasingly our design and construction clients who are going to be interested in early and cost-efficient dispute resolution are not going to want to hear that it's a sign of weakness, that of entertaining mediation. And I think that, these misconceptions and many others lead lawyers, I think mistakenly, to believe that mediation is a waste of time and money. Again, it's no panacea. I've had my frustrations, but I think that that it has tremendous value to start a settlement process early before the parties experience all the cost and inconvenience that comes along with litigation, because almost inevitably, and I don't have the statistics, but it's likely way more than 90% of the time, as parties get close to trial, their attitude about risk changes. And this is true for the lawyers and the clients, especially the risk of losing. When it comes to the psychology of resolving disputes, losses tend to weigh much more heavier on the psyche than gains. And people begin to get particularly concerned about the risk of losing. And, certainly I hope it's not the case that their lawyer promised them that they would recover their legal and expert expenses, their attorney's fees, because that is almost never the case in design and construction disputes. But parties, when they get close to trial, their attitude about risk may change if they start to get scared about the idea that they're not going to recover their attorney's fees from the other side, which leads to all sort of other settlement impediments, the sunk cost fallacy, and other things, which good mediators, certainly those who are using the guided choice dispute resolution principles, can help to try to push through. And certainly it's been my experience that most judges prefer not to devote court time to extremely fact-intensive cases. And, there are a few areas of law that I'm aware of, they're certainly out there, where you have more fact-intensive disputes. Disputes about delay and the critical path, disputes about construction cost accounting, even disputes where there may be dozens or hundreds of change orders. They can be very fact intensive, and it's not that unusual for a judge to need to clear weeks or maybe months to handle a design or a construction case. And while I'm certainly not suggesting that these judges are doing anything wrong, it is simply the case that many of these trial judges often attempt to push the parties in the direction of a settlement. It's certainly perceived oftentimes by the lawyers and their clients as being forced into a settlement. And so, these initial things that would cause design and construction attorneys to resist mediation and go through this expensive and painful and time-consuming process with their clients bearing all the burden of it, it so often leads, for one reason or another, whether it's a changing of attitude about risk or being, forced into a settlement, this tends to lead most design and construction disputes to resolve through a negotiated settlement, short of trial, but after too much time and too much expense. And I think that clients expect their lawyers to adapt to new realities. I mean, if we really want to get historical and geek out here, the Seventh Amendment, which guaranteed civil jury trials, which was effective as part of the Bill of Rights, I believe 1791, when it was written, the costs of electronic discovery were not in mind. These extremely expensive procedures that we have to deal with right now to gather up electronically stored information, that wasn't in mind at the time, right? And, the world has changed. And I think that, look, it's a fact, regardless of how many people are still thinking about this the way that it was conceived of years ago, decades ago, where all cases went to trial. In the late 80s and the early 90s, design and construction mediation became more prevalent. And that is probably part of the reason why so many of these cases tend to resolve short of trial. And, just like human beings have to adapt over time and think of themselves differently, I think that clients expect us lawyers to do the same. I mean, look, cravings for salt were really important to our caveman ancestors, but they're not so good for us now. And I don't know what purpose wisdom teeth serve right now. They were important at one point in the past, they're not anymore. And certainly I've only heard of people having their appendix removed. And so just because there were things that may have been useful in the past at a different time, before electronic discovery, before the rise of design and construction mediation, and certainly before some of these best practices around guided choice dispute resolution have really come to the fore, the world is different, but our clients, I believe, my experience is they expect us to adapt to these new realities. And as somebody who loves being a lawyer, I like to believe that lawyers' resistance to mediation is not about making more money. It's certainly a fact that these adversarial litigation and arbitration procedures are economically beneficial to lawyers that bill on an hourly basis. I tend to believe that most lawyers are not pushing litigation to the end before settlements because they're looking to line their own pockets. I believe that decades ago, it was the case that most design and construction cases went to trial, and a lot of lawyers, even those of my generation, people have been practicing for 20 or so years, we were taught by more senior lawyers that may have grown up in that everything goes to trial era. And so I don't believe that it's true that lawyers have bad intentions. I think that some of them just have a hangover from a bygone era, even some of those who like me weren't necessarily a part of that era, but we were raised by mentors who are of the idea that everything needs to be prepared for trial, and that we don't pursue these early cost-efficient dispute resolution methods. But I think that it's true that some of these early and cost-efficient methods of dispute resolution, whether it's mediation done right, how in whatever form, be it using the guided choice dispute resolution principles or in some other way, I think that these things are important because certainly there is an incentive, in my view, for lawyers to meet business people where they are. And in my experience, clients are going to reward lawyers who can get them earlier and less expensive resolutions, who can reduce the toxic effect of unresolved disputes that pen for long periods of time. I mean, show me an architecture firm that wants its project manager to have to support a lawyer in litigation for 100 hours next year, and I'll eat my hat. It doesn't exist. Construction companies want to build. Real estate developers want to, develop new and exciting properties. Architects and other design professionals want to do what they do best. They do not want a toxic dispute lingering around. And this is true, even setting aside how much it costs them, not just financially, but in terms of, the stress, the strain, and the time commitment. And I think that those lawyers who have figured out how to achieve those earlier resolutions, this early cost-efficient dispute resolution, I think that they're going to be able to reduce the risk for themselves, which I think they're going to see more and more in fixed fee arrangements or not to exceed fee arrangements, which I think are going to become more prominent. So, there's certainly reasons we can identify why design and construction attorneys resist mediation. It's, it certainly has to do with the fact that many attorneys like me have been involved in a lot of bad mediations, but you don't throw the baby out with the bathwater. And, if early cost efficient dispute resolution is something that interests you, I would urge you to pay more attention to Paul Lurie and guided choice, and certainly some of the other videos that I have on the topic of how design and construction clients can achieve early cost efficient dispute resolution.